So many people going to ChatGPT and asking when can a United States president just strike any location without congressional approval. And they find evidence in the past and don't think of the context. They don't think, why was it that we struck Cambodia? What was happening in Cambodia? They don't ask, why did we go to Vietnam? Because then you would acknowledge the context of nuances that ChatGPT doesn't give you. So let me provide that to you. The reality is that the government allows for certain instances of strikes, but this has to be within reason, right? One is non-state actors. That is basically proxies. They're not government establishments, they're not government locations. These are much more like the Houthis and organizations like these, right? They're not directly tied to a government, even though everyone knows that they're the proxies, but technically there is so much division between like a government and their proxy that everyone just pretends that when the proxy does something it's not actually the government. But everyone knows it happens all the time. The United States gets Mossad to do a lot of things in the Middle East and South Asia, so it's not a surprise in geopolitics. International law is just how it works. People know, but it's not a declaration of war. Another would be, attacking a territory that isn't technically officially recognized as a country, such as, technically peacetime would count. However, peacetime is part of the International Criminal Court, the Rome Statute, so the United States would not want to do that because it would literally erode away any integrity that the United States has under international law. It doesn't really have anymore, but like totally they wouldn't do that. When we think of why is it that there has been no justice for what happened in Guantanamo Bay, but there was for what happened in Abu Ghraib, it's because Abu Ghraib had so much evidence that the United States had to give something to the international justice to say that we're actually, taking these things seriously, but they didn't give anything when it comes to justice for Guantanamo Bay. So the United States is very logical about giving in some to international law without giving in everything, because we're not held accountable under the international law because it's soft law for us. Why? Article 6 supremacy clause, the constitution is the law of the land, which means that the politicians and lawmakers, that the president and the executive nor the courts can actually change the constitution unless there is an amendment. So if the constitution is the law of the land, that means that only American constitutional foundations, not international mandate, can actually have jurisdiction over Americans who commit international crimes. So let's go back, right? So we technically could on territory that isn't officially a country, because you're not declaring war on a territory that isn't a country with a, official government, even though we do recognize the PLO, but ultimately there's enough ambiguity there for there to be a gray zone, right? Another is R2P, responsibility to protect, which is something that we kind of used during the War on Terror. Look, they're beating up women. Look, they're beating up gay people. So ultimately, we can technically utilize something like that in order to gray zone and actually prevent atrocities from happening, to prevent something like the HCAS, something like the Rwandan genocide, which we did not prevent, by the way. It was the Rwandan Patriotic Front. We just looked away and gave them peacekeepers who didn't actually do anything, kind of like my governor, who isn't actually doing anything. But that's not the point. The fourth point we gotta make is the fact that if the Constitution is the law of the land, that means that the Constitution can change U.S. law. U.S. law, including legislation, cannot change the Constitution unless there is legislation and amendments that actually change that. That is Article 5. That isn't a legislation. So the Constitution is always above the legislation. It is always above the rule of law. Something that is illegal is under unconstitutional. If you do something unconstitutional, that's more severe than doing something illegal, because the law is derived from the Constitution, right? So the law cannot go against the Constitution. The fact that we have things that go against the Constitution is literally misaligned to our constitutional foundation and constitutional supremacy. So that tells us what? That the courts have been misaligned to the constitutional design. And that's no surprise, because the courts are not aligned by Article 3 of the Constitution because it's incomplete. Actually, Congress utilizes Federalist 78 through 83 in order to design it, which means that the courts depend on Congress and Congress depends on the courts. Interdependent, right? Conflict of interest. So ultimately, this crisis has been long gone, but the reality is that the insurrection itself positioned such an erosion in the constitutional order that now it's up for interpretation, kind of like the Bible in a religious text. We know this because Federalist 78 by Alexander Hamilton positions that the courts of justice, whose duty duty must be to declare all acts contrary to the voice of the Constitution void. Now, there's enough room here to say, well, what interpretation of the Constitution, right, that a judge can put forth. But if Article 6 Supremacy Clause tells us that the Constitution is the law of the land and you cannot go against that, even in the reality in which there's legislation, because that will be void, it positions that if the courts fail to be independent and prioritize constitutional supremacy, without this, all the reservations of particular rights or privileges would amount to nothing, which is what we're experiencing. To process all of these things, they're all taking a long time in order to be capable of being dealt with because there's so much ambiguity that basically, if it's not forbidden, then it can be allowed. But that's because our founders didn't actually recognize that the Constitution can be eroded by authoritarianism because there was good faith in American exceptionalism. There is no position which depends on clear principles than that every act of the delegated authority contrary to the voice of the commission under which it is exercised to the Constitution is void, should be null. No legislative act, therefore, contrary to the Constitution can be valid. If the Constitution only gives an act of war to Congress, then it means that the president should ask Congress. Now, there's a difference again between a non state actor, there's a difference between an imminent threat, and there's a difference between what happened with Iran. Iran, there was no imminent threat. Iran, there was no actual attack on the United States. The fact that it attacked Israel is in the United States. They are not in NATO. We have no obligation to Israel. So, in this reality, we put ourselves in a situation where we had zero to do in, right? A breach of international law, but that's soft law, so no one's going to hold us accountable but we. But a breach of constitutional law, which is supreme because Article 6 Supremacy Clause says the Constitution is the law of the land. And if that's not true, then it's void, right? Which means that the constitutional virtually dissolves. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtues of powers may do not only what their powers do not authorize, but what they forbid. So if within a contract, anything within the social contract of the margins is the only one that's binding, why is it that we don't hold that supremacy within our constitutional doctrine, right? And that is the problem of the court. If it is said that the legislative body, so Congress, are themselves the constitutional judges of their own powers and that the construction they put upon them is conclusive upon the other departments, it may be answered that this cannot be the natural presumption where it is not to be collected from any particular provision in the Constitution. So in order for Congress to remove the fact that he has to go to Congress in order to get war okayed, they have to make an amendment, Article 5, or we have to make an amendment, Article 5. Now, they position that the judiciary is the weakest branch of governments because it's not supposed to be political, it's just supposed to interpret the Constitution. Note that this conclusion by any means supposes superiority of the judicial to the legislative power. It only supposes that the power of the people is superior to both. Again, the Constitution, not democracy, and that where the will of the legislature of Congress declared in its legislation stands in opposition to that of the people declared in the Constitution, the judges ought to be governed by the Constitution rather than legislation. Until the people, by some solemn authoritative act, Article 5, annul or change the established form, it is binding upon themselves collectively as well as individually. No presumption or even knowledge of their sentiments can warrant their representatives, and in departure from it, parts of such act. You see, legislation cannot subvert constitutional provision. And more clearly, in regard to the infering acts of a superior and subordinate authority, so Constitution versus legislation of an original and derivative power, the nature and reason of the thing indicative to converse the rule as prepared to follow. So this is how it should be calculated. They teach us that the prior act of a superior ought to be preferred to the subsequent act of an inferior and subordinate authority, and that accordingly, whenever particular law contravenes the Constitution, it will be the duty of the courts to adhere to the Constitution and disregard the law, including legislation. In that reality, you cannot say that, he's supposed to ask Congress and then say, well, to be or not to be, no, it's in English. It is in English. There's a difference between arguing over healthcare and arguing over war. Congress is the one who allows that, and saying that you vibe that they had something to attack us with doesn't mean it's true.